I'm assuming, and you can correct me if you feel differently about this, that you were going to argue these two cases as separate cases.
Your Honor, this is Michael Clark on behalf of the appellants. Is it correct that there is 20 minutes of time devoted to both cases?
There's 20. Each case is on the docket as a separate case, so each case would have 20 and 20. If you want, you can combine them. Maybe we would do 30 and 30, however you want to do it. But I'm flexible.
Okay, Your Honor, the request of the appellants would be to devote the lion's share of their time to the second appeal and take that case first and argue them jointly.
Mr. Baca, how do you feel okay with that?
Whatever is most convenient for the court is fine with me.
Well, why don't we do this? Why don't we combine the cases and do 30 minutes aside? Is that doable?
That is more than sufficient time for the appellant, Your Honor.
How about you, Mr. Baca?
Yes, Your Honor.
We were a little worried about you there for a while. We're glad it's good to see you.
It's that whole technology thing.
Yeah, no kidding. All right, so we are going to combine cases. The USAA, is it Boucher? Boucher. Boucher. We're going to combine those two cases and 30 minutes aside and have at it, Mr. Clark.
May it please the court. My name is Michael Clark, and I'm here today on behalf of USAA Casualty Insurance Company and USAA Insurance Company. I'm requesting that 5 minutes of the 30 minutes be reserved for rebuttal.
Sure.
Your Honors, I'm here today requesting the relief on the appeal of the partial final judgment for a reduction or grant of a new trial or reduction of the damage pursuant to the directed verdict made on the claim for future earning capacity or a remitter of that element of the damages. As it relates to the appeal concerning the proposal for settlement, we're requesting under de novo review specifically that USAA Casualty Insurance Company, who is the only party that is subject to the final judgment for the award of fees, that proposal be found invalid, that the award of attorney's fees be reversed in its entirety, and alternatively, that the court, if it finds the proposal to be valid and in compliance with the statute and the rule, that non-compensable hours be reduced, or that those hours that are not supported by competent substantial evidence be reduced. And with that, I'll just briefly get into some of the facts of the case. This is a action brought by Mr. Boucher against both USAA Casualty Insurance and USAA. Originally included the tortfeasors, but by the time the case went to trial, they were no longer part of the lawsuit. The remaining defendants were only the USAA companies. Mr. Boucher is an attorney, and in a unique set of circumstances, he was actually an attorney employed by Mr. Robert Joyce, who represented him during the course of this action. Importantly, when it comes to future earning capacity, he was a salaried employee of Mr. Joyce and was paid a salary as his employee. This was a 4-day liability trial. No contest of liability, no contest of causation of permanency injury. So those were undisputed facts, tried over 4 days in October of 2019. After the suit was filed, Mr. Boucher did have spinal surgery at the L5-S1 level. And ultimately, the jury here awarded almost $3.7 million in damages, including $900,000 for a loss of, $900,000.00 of future earning capacity, $600,000 in past non-economic damages, and $1.5 million in future non-economic damages as a result of this accident. That verdict was reduced to the policy limits, $100,000 for USAA Casualty Insurance, $1 million for USAA, and that's the partial final judgment that is the subject of the first appeal. Depending upon the outcome of what that appeal is, the appellee is, unless we're granted a new trial, the appellate is going to continue to pursue, I would presume, the excess judgments, as well as the bad faith claims that we're going to talk about. As it relates to the proposal for settlement, the one that is at issue was served on July 6, 2018, and it's in the record at page 4345, 4356. Now, the trial court found that to be valid. There was a hearing on the claim for attorney's fees, and after that evidentiary proceeding, the trial court awarded $809,590 worth of attorney's fees to 5 separate timekeepers. So as I've indicated to the court, I'm going to devote the lion's share of my argument issued to the de novo review of this proposal for settlement. Originally, the complaint as filed by Mr. Boucher included the tortfeasors in count 1, a claim for against USAA-CIC, and then in count 3, a bad faith claim against USAA-CIC, alleging violations of 624.155, also seeking attorney's fees claims and prosecution for and his claim for benefits, and also seeking, as a result of the act of the alleged actions in bad faith of USAA-CIC, attorney's fees pursuant to 624.155, 627.72710, and 627.428. And that is clear from the original pleading in this case that those claims, those legal claims for attorney's fees, were present since the onset of this litigation. Before USAA-CIC even had an opportunity to respond, specialized counsel came in and filed a motion to dismiss. Before USAA-CIC even had a chance to respond, Mr. Boucher amended his action. And at that point, he put forth a first amended complaint, the difference being that he added a count against a count against USAA, and then in a fourth count to the complaint, again, alleged bad faith, not only on behalf of USAA-CIC, but on behalf of USAA as well. And it's critically important that when as the court has reviewed this record, I'm sure, and the briefs, they've seen that this first amended complaint in count 4, the relevant pages are pretty well condensed at 124 through 127 of the record before the court, that the allegations of Mr. Boucher at that time included, separate and apart from any contractual actions for benefits, allegations of bad faith under 624.155 causing damages, including interest on unpaid benefits, pre-judgment interest, and attorney's fees incurred by the prosecution of these claims for uninsured motorist benefits as a direct and proximate result of the failure to act in good faith. Plaintiff alleged that he had to retain the services of Mr. Joyce and that he was also entitled to attorney's fees to bring this action against USAA and USAA-CIC by operation of law, including section 627.428 Florida statutes. And if there's any doubt as to whether or not that first amended complaint contains a legal claim for attorney's fees, the wherefore clause itself requests attorney's fees pursuant to 624.155, 727 subsection 10, and 627.428. That's the pleading that's before the court that is relevant to the issue concerning the proposal for settlement. Now that proposal for settlement, then this is what, that first amended complaint is obviously making a claim for bad faith as well as legal claims for attorney's fees. It was at that point that additional counsel was retained. A motion to dismiss the first amended complaint was filed, requesting the dismissal of the bad faith claims that ultimately was abated. Those claims were abated pending the outcome of the underlying contractual actions. On the same day that first amended complaint was filed, Mr. Boucher also filed a civil remedies notice with the Florida Department of Financial Services. Civil remedies notice is in the record at 2D20-504. And what it claimed there was, and I'm going to just paraphrase what it would take to cure, to resolve the claim as it related to USAA CIC. The cure requested was the payment of the $100,000 policy limits for a complete and full resolution of any and all claims of Kevin Boucher, known and unknown, including any and all attorney's fees and costs, as well as any and all alleged damages for any potential bad faith claims stemming directly or indirectly from the subject motor vehicle accident. So again, at the time that the First Amendment complaint was on file with the court, there was a CRN that was filed on behalf of Mr. Boucher, seeking to have the policy limits paid, as well as that cure would resolve any claims for attorney's fees or any potential bad faith claims. So now we have the PFS, which is at page 4346 and 4345 and 4356 of the record. And that was the one that the trial court ultimately enforced. The proposal was made by Mr. Boucher, and the party to whom it was made directly states USAA casualty insurance for policy number, and then it provides the policy number only. The resolution proposed of that for the policy number identified was it would resolve all claims for damages that would otherwise be awarded in a final judgment as alleged in the complaint against USAA Casualty Insurance Company for policy number, insert the policy number there only. And then the next paragraph, paragraph 4 of the proposal, says that the relevant monetary conditions in terms of the proposals would allow for the plaintiff's counsel to file a voluntary dismissal with prejudice of all of the claims identified in paragraph 3 above upon timely payment of $30,000 for the policy number identified. And here, most importantly, to my first argument, is that in addressing the attorney's fees as required under the rule, the statement is the proposal does not include attorney's fees, and attorney's fees are not part of the legal claim unless successful under the proposal for settlement. So when this court on de novo review compares the allegations within that first amended complaint at paragraphs 30 through 35 that I've already identified for the court to the terms of paragraph 7 of this proposal for settlement, it's very easy to see where I'm going here. I don't think there can be any objective disagreement on the idea that that first amended complaint absolutely contained a legal claim for attorney's fees. And I don't think there's any way around looking at the facts as I just stated them. So let's get to the de novo review that the court will employ to those facts. I think there's one important point I want to make up front, which is my arguments concerning enforcement of the proposal have two different prongs to them. Proposals can be found to be invalid because of a technical deficiency for compliance with the rule and the statute, or they can be found under a test finding ambiguity in the proposal, thereby invalidating it. And that ambiguity test is well known to this court. The court is encouraged, as through the Florida Supreme Court's opinion in State Farm versus Nichols, and has indicated that it is not going to nitpick and allow Monday morning quarterbacking, to avoid an award of attorney's fees. And the test for ambiguity says it has to reasonably affect the offeree's decision to accept. We don't disagree with that test as it relates to ambiguity. The first test, though, that we're going to employ in reviewing it is whether it's valid. And the argument that is presented there within the briefs is that the Rule 1.442 C2F requires a statement of whether the proposal includes attorney's fees and whether attorney's fees are part of the legal claim. And that term in the rule has gone through the Florida Supreme Court and has been reviewed as to what exactly that requires in a proposal for technical compliance with both the rule and the statute. First important case is Diamond Aircraft versus Horowitz, where the Florida Supreme Court reviewed on certified question from the 11th Circuit Court of Appeal the following certified question. Under Florida Statute 768 and Rule 1442, is a defendant's offer of settlement valid if in a case in which the plaintiff demands attorney's fees, the offer purports to satisfy all claims, but fails to specify whether attorney's fees are included and fails to specify whether attorney's fees are part of the legal claim. And in answering that question in the negative, the Florida Supreme Court said that we conclude that the defendant in that case would not be entitled to attorney's fees under the section because Diamond Aircraft, the defendant's offer of settlement did not strictly comply with Rule 1.42, as it did not state that the proposal included attorney's fees, and attorney's fees are part of the legal claim, thereby necessitating the presence of the offer of settlement, a specific statement regarding those attorney's fees. And in looking at that and looking what the Florida Supreme Court was saying was, since the plaintiff had made a claim for statutory claim for attorney's fees under Florida's Deceptive and Unfair Trade Practices Act, when a proposal for settlement was served that did not make that required statement under Rule 1.442 C2F, the proposal is invalid. Not a question of ambiguity, a question of compliance with the statute. Since Diamond Aircraft, the Florida Supreme Court looked at this, that same provision of the rule again in Cahuta versus Borden Dairy, 2016 case. It reaffirmed its holding of Diamond Aircraft, essentially saying that if a legal claim for attorney's fees are included and a part of that legal claim, and they're part of the legal claim, that has to be stated specifically in the proposal for it to be in compliance with the rule. However, the court refused to find invalid a proposal for settlement that made no statement if those legal claims weren't present. So what the court was saying was, if there is no legal claim in the operative pleading that we're looking at for the resolution of these claims in the proposal, you don't have to make a statement. That's not the case here. Again, the record clearly shows that there are 3 separate claims for legal fees or attorney's fees under the basis which I've identified. Now, I think what's telling is that Mr. Bosher in his answer brief does not address those authorities. And essentially, the opposition argument to that is that you don't have to look at this because if USACIC had accepted the proposal for settlement, it would have resulted in the dismissal of the case, would have settled the case, would have dismissed the case, and there would have been no ongoing suit. It would have been moot, so to speak. Not so to speak, but moot. And I think a very important decision from this court showed why that argument has to be rejected. And it's a case that still only has a Westlaw site, but it's Milling versus the Travelers Home and Marine Insurance Company, and it was cited in our reply brief at page 7. And in that case, what this court reviewed was a suit brought against Travelers. There was no contest of coverage, and during the litigation of that suit, a civil remedies notice was filed against Travelers. Ultimately, Travelers settled the case, and there was a stipulated partial final judgment. And part of the stipulation was that there was bad faith claims handling under 624-155, and that the trial court was going to retain jurisdiction to review legal claims for attorney's fees. The 2 claims that were at issue there were Travelers, a claim under 627-7210 for Travelers failure to act in good faith for the bad faith statutory violations, and for under 624-155, including 627-428, because of a failure to act in good faith, they were required to retain their trial counsel to pursue that action. And what the trial court did there was, in determining the fee motion under those legal claims for attorney's fees, they denied the claims. And what this court wrote in reversing on both of those things with emphasis added, was that the damages recoverable for an uninsured motorist carrier in an accident under 624155 include the total amount of claimant's damages, and with emphasis stated, reasonable attorney's fees and costs and any damages in violation of the law. And that's 627, 72710, straight out of the statute. Here, that's attorney's fee claim, legal claim number one. And what this court said was contrary to the trial court's conclusion, 627728 does not preclude, that's the fee triggering statute of the does not preclude milling for recovering attorney's fees as damages. Because coverage was not contested, the trial court was correct insofar as milling not being entitled to recover as a prevailing party in the underlying case. However, the attorney's fees were not sought as a prevailing party under 62728, but under 624155, which permits recovery for reasonable foreseeable damages resulting from the insurer's bad faith conduct, including reasonable attorney's fees. That's legal claim number one. Same legal claim that's in this first amended complaint. Legal claim number two is for the claim in pursuit of excess, the excess judgment under 6241554, which states upon adverse adjudication, trial, or upon appeal, the authorized insurer shall be liable for damages together with court costs and reasonable attorney's fees incurred by the plaintiff. And again, this court reversed the denial of the fees there, saying the existence and amount of milling's damages, including whether and how much of the fees incurred litigating the underlying action were the natural approximate probable cause of direct consequence of the insurer's bad faith, was a part of the bad faith suit, and as such, attorney's fees incurred for such litigation should be awarded under the prevailing party standard. Now, obviously, Your Honors, that's not a proposal for settlement case, but I bring it up because of the analogous facts to the case that are here, and to rebut the argument that Mr. Boucher made in his answer brief, that USAIC just should have ignored this. They should have ignored the content of the First Amendment complaint in evaluating what claims were being made, what ultimately this court is going to be encouraged to do, which is also to ignore it, because it's there. It can't be ignored. There is technical noncompliance. The claims are there, period. But the proposal for settlement does not address those claims. So yeah, that's why I bring up the milling case, because it is on point to make it very, very clear that those legal claims were part of the operative pleading at the time this proposal was made. So under the strict construction of 1.442 C2F and the application of Diamond Aircraft and the Cahuta case, the proposal is invalid, and this court is requested to reverse. I'm going to speed things up here a bit. The second point is that the complaint, the proposal identifies a complaint, not the First Amendment complaint. And I think that that's important because, as everybody knows, we've been encouraged, and I admit that the trend in the case law is to ignore what could be non-consequential typographical errors. But this isn't a non-consequential typographical error because of the same principles we were just talking about. There was a claim pending, there was a bad faith claim pending, there was a CRN that was pending, and there was a legitimate question as to why Boucher would use the word complaint when that was no longer an operative pleading and had been superseded. That could reasonably have affected USAIC's decision whether to accept it. And the third point I want to make is, again, on ambiguity, and that is the contrast between paragraph 3 and paragraph 4 as to what claims would have been resolved had this case, or had it been accepted. And in that instance, the claims that would have been resolved, as stated, were arising from the policy only, as in paragraph 3, but in paragraph 4, they state only, it would only dismiss the claims identified in paragraph 3. So what would have happened to count 4? The count 4 does not arise from the contract or the policy. Count 4 is a completely independent cause of action. That's an ambiguity. The case that I rely most there is Senez versus Campos, 967 Southern 2nd, 1114. It's 4th DCA case from 2007. Analogous situation. The only difference is the CRN in that case had not become, there was no pending bad faith action, but it was out and it had not been cured. And in that case, the proposal said in paragraph 3, it would resolve all claims against the defendant. But in paragraph 5, it said it would be full settlement of all claims raised in the suit. And what the trial court found there, they accepted the insurer's argument. It was unclear as to whether the proposal addressed the bad faith claim that had been noticed under the civil remedy statute. And what the 4th district found was that no one can claim that paragraphs 3 and 5 say the same thing. They simply don't. They conflicted. The wording created an ambiguity that supported the trial court striking the proposal. And that's what we have here. Again, you can't say that these things say the same things. They don't. They don't say that they're going to definitively resolve count 4 and that bad faith claim. And the court, in that case, there was a dissent, and the majority said, look, one of the things you need to be concerned about is a common law bad faith claim is for something other than an excess verdict. And the attorney's fee claims provide for claims other than excess verdicts, including fraud, breach of contract, intentional infliction of emotional distress. So that's why it's
Mr. Clark, you're down to 5 minutes, so use them as you wish.
I will use them by moving on to 2 points as it relates to the attorney's fee award. One, this court has been provided with a record of an annotation that shows under competent substantial an exhibit from our expert that shows that Mr. Joyce's 1,200 hours at $700 per hour are not compensable as a matter of law. When the court reviews the annotated timesheets, you'll see in the case I relied on are Youngblood versus Youngblood and North Dade versus J.M. Strickland, hour after hour after hour of essentially paralegal time, communicating in the office, telephone calls, judicial assistance. Those things aren't compensable. It's error as a matter of law to award them. So I request the court to look there. And then as it relates to the underlying verdicts, I will rely upon the briefs except for the future earning capacity. USAA moved for directed verdicts. The court allowed Mr. Joyce to reopen the case and rely upon some testimony from from Jerry Panicia as a functional capacity evaluator. And here's the point. Plaintiff's theory on future earning capacity is that he loses 6 minutes an hour as an attorney because he has to reposition himself. And that 6 minutes an hour causes him to have a lack of focus, thereby equating on a 40-hour work week to a 20% loss of earning capacity. And you know, that's not the law. The law is that it has to be reasonably certain. So what they did was they threw some numbers out there and said, he loses 6 minutes an hour. His salary's X. Jared Panicio says that an attorney is going to be making this amount of money. What I want you to do is just multiply these things. That meets the reasonable certainty standard. It doesn't. It doesn't. There was no proof that there was any loss of future earning capacity here, only that at best, Mr. Boucher would have to work longer to earn the same amount of money that he could have. That's not a loss of future earning capacity, and it does not fit the standard under W.R. Grace, and it should have either been the directed verdict motion should have either been granted, or the remitted should have been granted to a reasonable fee, or I'm sorry, a reasonable award of attorney's fees that's supported by the evidence. So otherwise, I'm going to rely on the briefs for the partial final judgment appeal. Thank you, Your Honor.
You have about 2 minutes of rebuttal left. Okay, Mr. Vaca, you're up.
Good morning. Thank you very much. May it please the court, George Vaca on behalf of Kevin Boucher. we're asking the court to affirm both the partial final judgment and the judgment on fees and costs pursuant to the proposal for settlement. At the outset, I'd like to maybe point out something that's quite obvious to the court, but USAA in the main appeal has raised 6 different issues on appeal. And although they've paid lip service to the standard of review, they've not in one instance demonstrated how of the 5 of those 6, all are abuse of discretion. They have not demonstrated at all. In fact, they haven't even argued that no other reasonable trial judge would have ruled the way Judge Peacock did on these 5 issues that they assert. So I know that USAA is just relying upon the briefs, but in each one of these situations, with the exception of the directed verdict, all of those are subject to an abuse of discretion standard. And I would suggest to the court that at a minimum, reasonable people could differ as to the propriety of various rulings about which they complain. And as such, the court knows that it should then affirm those decisions and the judgment upon which it is based. If the court has any questions about any of those individual issues, whether it's the mental health records that Judge Peacock said they are privileged and you can't get them, whether it was the way that the court reached some type of compromise regarding the surveillance, the late listed surveillance, or actually the late surveillance that was conducted in violation of the pretrial order. Or if there's any questions at all about limiting the scope of Dr. Ziti's testimony, you may recall at the hearing on the Daubert hearing that was conducted on that, Mr. Joyce provided the court with, 10, 15, 20 different orders from different courts around the state, limiting Dr. Ziti's testimony in similar fashion that Judge Peacock did. And while those are not binding on this court in any way, they certainly are indicative that Judge Peacock's decision was not one that another reasonable jurist would have made when other reasonable jurists did make those exact same determinations regarding his testimony. The same can be said for the closing argument and the request for a new trial. Judge Peacock, who was in the best position to observe what impact the closing argument may or may not have had upon the jury, said that the one reference or 2 references to religion that kind of raised her eye was not something that was pervasive during the course of the closing argument, that it was short, and certainly USAA has not done anything to demonstrate that it can satisfy the Murphy test with respect to the parts of the closing argument to which its trial lawyers did not object. They haven't demonstrated that the argument was improper. They haven't demonstrated that it was harmful. They sure haven't demonstrated that it was incurable. And they most definitely have not shown that it so damaged the fairness of the trial that the public system of justice requires a new trial because of how this jury ruled. I mean, they simply haven't done that. So we've got 50 pages of an initial brief, which basically ignore the standards of review and sit there and ask the court to go ahead and to reverse. With respect to the directed verdict, I would simply cite the court to its own decision, a recent decision involving USAA, which is the Ray decision that was authored by Judge Lucas. I happen to be the lawyer on the losing side of that case, where we had received a directed verdict in a negligence case pertaining to injury. And the court wrote in that case that directed verdicts in negligence cases should be very, very rare. And if there's any conflicting evidence, it ought to be presented to the jury. And in this case, it is unquestioned that there was, and I hate to correct Mr. Clark, but nobody except for the defense lawyers in this case said that Mr. Bosher lost focus at work. What the physicians, Dr. Tolley and Dr. Martinez, said was that he needs to get up every hour or so to walk around to alleviate his pain. Not because he had a lack of focus. It was that same bogus argument that he used to try to bootstrap getting the mental health records by saying, well, his ADHD, he lost focus, and therefore that in some fashion impacts his lost future earning capacity claim. That simply isn't the case. So what the testimony was that he needed to walk around for 5 to 6 minutes every hour to alleviate his pain. And I don't think it takes an expert witness to figure out that if you're doing that every hour and you're working so many hours a day, that you are going to lose however many hours times however many minutes in productivity, which is what Ms. Panaccio talked about and what Mr. Joyce read from her deposition. Not the least of which also is to not forget that Ms. Panaccio was their expert witness, not Mr. Joyce's. So unless the court has some questions about the actual trial or anything that was raised in the initial brief, we would assert that they've not demonstrated that any of the discretionary rulings were the result of an abuse of Judge Peacock's discretion, and that the DV and the rejection of the DV was appropriate because there was competent substantial evidence provided by those three witnesses and Mr. Boucher himself to support the idea that he would be losing productivity. He's the one who testified, you may recall, that he had to come in and work an extra day each week to make up for the lost time that he spent while he was walking around to alleviate the pain. That testimony was not impeached at all. And so we would suggest to the court that the denial of the directed verdict was appropriate and that judgment should be affirmed. Moving on then to the proposal for settlement. And it's amazing to me, Mr. Clark sat here with this court and has said it before about you need to look at the complaint, the amended complaint, the second amended complaint, and compare it to the proposal for settlement. And yet every single time in this argument, there is a specific allegation in every one of these complaints that he ignores. And that allegation is first in paragraph 21 of the initial complaint. It's in paragraph 26 of the amended complaint. And it's in paragraph 26 of the second amended complaint. And that paragraph reads as follows. This pertains to insurance bad faith. This claim will ripen upon the determination by the court or by confession of judgment by USAA Casualty Insurance Company that plaintiff is entitled to the limit of uninsured motorist benefits under these policies. So in the complaint, it's recognized that the claim for bad faith does not yet exist and will only exist in the future if certain things happen. Now, that's not anything that's astonishing because the case law in this state is and has always been that before you can go forward with a bad faith case, you have to first establish your entitlement to benefits under the policy and establish what your damages are. That's in Vest, that's in, oh my goodness, I don't know how many different cases that the Supreme Court has said that. Blanchard, it goes on and on and on, okay? There is no bad faith case until you establish those things. Mr. Boucher would not have a bad faith case whatsoever had USAA done the very simple thing, which was to accept this proposal, pay $30,000, upon which, okay? So the proposal itself, paragraph 3 says, the proposal resolves all damages that would otherwise be awarded in a final judgment in the action in which the proposal is served, subject to subdivision F of the Rules of Civil Procedure 1.442 for the claims made by Kevin Boucher as alleged in the complaint against USAA Casualty Insurance Company for policy number, and then he identifies the policy number. Paragraph 4 says, plaintiff's counsel will file a voluntary dismissal with prejudice for the claims identified in paragraph 3 above upon timely receipt of payment. So all damages, all claims, and a voluntary dismissal upon receipt of the payment. Now, I beg to differ a little bit with Mr. Clark regarding the search for an ambiguity where none exists. Mr. Clark says, well, we were confused as to whether or not you were talking about the claims, I guess, in the complaint versus the amended complaint. However, those allegations are identical. More importantly, I think the true test of all this is if USAA accepted this proposal for settlement and Mr. Joyce said, oh, thanks for the $30,000, I dismissed the complaint This doesn't pertain to the complaint. It pertains to the, I get to go forward on the amended complaint. Okay. It is likely that a trial court would have sanctioned Mr. Joyce for that behavior, and rightfully so, because it would not have been done in good faith. Nobody would reasonably read the proposal for settlement as saying, hey, I want you to pay $30,000 for the claims asserted just in the complaint and not get a dismissal of all of the case, of the entirety of the case. I mean, that's just unreasonable. That's the very type of ambiguity the Supreme Court has frowned upon and when discussing whether courts should enforce the proposals for settlement.
I understand your reading of paragraphs 3 and 4. Can you go over paragraph 7 and explain why you worded it the way, or your client worded it the way that he did?
Because until there is an entitlement to go forward and the bad faith claim is right, there is no entitlement to attorney's fees for purposes of this claim.
Particularly are not part of the legal claim. Attorney's fees are not part of the legal claim in the complaint. I mean, wouldn't it have been easier to word it where they are part of the legal claim and identify when that is the case?
Well, I think that's in the.
This is the one part of this case that I'm really struggling with. Why, if somebody's on the other side and they receive this, that I'm looking at your complaint, what it includes in it, and then paragraph 7 there, just I'm struggling with that. So help me understand.
Sure, absolutely, Your Honor. So part of this comes about because historically in uninsured motorist cases, if you go look at Florida statute 627.727 subsection 8, okay, historically attorney's fees are not awarded in cases involving claims for uninsured motorist benefits. They are awarded only when the insurance company raises an issue that calls into question the coverage. Otherwise, the carrier simply stands in the shoes of the tortfeasor. The case goes forward as more as a tort case as opposed to a contract case, and the plaintiff presents his or her evidence regarding the injury sustained, the damages sustained, and it goes forward that way.
Your position is essentially the same as it is, or it piggybacks on the same idea as the paragraph 3 versus paragraph 4. If this proposal for settlement is accepted, there's no bad faith claim, and there would not be an attorney's fee liability.
Going back to my question, though, sorry, Judge Norton, I didn't want to cut you off, but I didn't feel like he'd addressed my question where it says the proposal does not include attorney's fees. Why did you not word it? Because you're talking about this proposal. Why wouldn't it not say the proposal includes any and all claims for attorney's fees made in the complaint, so that they pay it, they know it's done, and they move on, as opposed to wording it and saying it does not include attorney's fees and that they're not part of the legal claim?
Because as the status of the pleadings at the time, Your Honor, was that there was no entitlement to fees that even existed at that point. It wasn't right.
But my question isn't about entitlement to fees. It's about what your proposal includes. Did your proposal include settling everything, including the attorney's fees, versus the proposal does not include attorney's fees?
The proposal
and then saying that it's not part of the legal claim. Wouldn't it have been easier to say clearly up front, this proposal takes care of everything, including the attorney's fees that might be due under the complaint as worded?
Your Honor, the proposal states that it resolves all damages that would otherwise be awarded in a final judgment in the action in which the proposal is served. It resolves all of them.
The legislature and the rules all call attorney's fees as a separate and apart, so that everybody's clear on attorney's fees.
And there is the posture of this case is that at the time this proposal is served, there is no basis to claim attorney's fees. So
I understand that. And you keep going back to that, but the purpose for the proposal is so that someone, when they get it on their desk, knows, okay, I pay this amount of money and X, Y, and Z are all taken care of. They're all wrapped up. But then paragraph 7, are attorney's fees taken care of? Did it take care of everything? If they paid $30,000, was it done?
Well, you know, to be fair, the rule 1.442F or 2F says the proposal must state whether the proposal includes attorney's fees. This one says the proposal does not include attorney's fees, and whether attorney's fees are part of the legal claim. And it says attorney's fees are not part of the legal claim unless successful under the proposal for settlement. So you know, I haven't decided the case yet, but my view of that is that this language was tracking the rule, what was required under the rule. I see where you're coming from, Judge Scargill, in terms of, you know, someone could possibly treat that as ambiguous, but I think then, although this language clearly technically complies with Rule 1.442, the question then I think would be whether it becomes ambiguous. And the question there is that ambiguity nitpicking under the case law?
And if
you're
I
supposed
might,
to say, yes, Judge, you're right.
Well, no, I wasn't sure if you were addressing me or if you were addressing.
No, I was just addressing the issue that's being discussed. That this language tracks Rule 1.442.
Correct. It's identical.
Yeah.
And so the question then becomes, at least in my mind, whether someone who is familiar in the handling of uninsured motorist claims, who knows that you are not entitled to fees simply by virtue of making the claim for uninsured motorist benefits, would legitimately have some doubt about whether they could accept this and end the case. And my suggestion to you, Judge Stargill, and to the rest of the court is that based upon the long history of law in this state pertaining to attorney's fees, and based upon the clear language of 627.727 subsection 8, there would not be a reasonable doubt in the mind of anybody who is the recipient of this offer, who knows about uninsured motorist claims, that there was no legal entitlement to fees for the uninsured motorist claim, and that such a claim for fees could only arise, as articulated in the proposal, either through this proposal for settlement or much later down the road in a different cause of action that Mr. Clark's client knew did not yet exist and was not ripe because they moved to dismiss it based upon the Fridman case, which stands for that very proposition. So there wasn't any ambiguity here for them. There wasn't anything that caused them a legitimate doubt, or shouldn't have been, about what would happen if they accepted this proposal. All elements of damage for that uninsured motorist claim was covered under this proposal for settlement. And the only time that the fee would have become an issue was after they rejected it, like they did here. The second thing I wanted to talk about with the court was their argument on this proposal for settlement that there wasn't competent substantial evidence for Judge Peacock to rely upon in making her decision. Now, the order clearly states that she relied upon Sarkis and Quanstrom, and she goes through those factors in her order. But she was also very detailed about what the evidence was and what it was that she relied upon. So she relied upon Mr. Joyce's firm's billing records. She relied upon my firm's billing records. And then she heard testimony from two experts. She heard testimony from former Circuit Judge Herb Berkowitz and from Mr. Regensdorf. Mr. Regensdorf freely admitted that he was unfamiliar with one of the critical factors to the Quanstrom analysis, which is what is the prevailing rate in the community of lawyers for the type of work that was being performed based upon their level of skill and experience. Mr. Regensdorf's basis for his testimony was a hypothetical rich man who could afford to pay any lawyer any amount of money, and his own personal opinion that he would only pay up to $400 an hour for certain services, is my recollection. Maybe it was $450. But there was no basis, no factual basis upon which that opinion was premised. The judge heard from Judge Berkowitz, who had heard various fee hearings, is familiar with the community of lawyers, is familiar with the experience levels of the lawyers who was involved, and who relied upon and reviewed various other fee awards where the same or similar types of fees were awarded to the very same lawyers who were involved in this case. So there clearly was, I understand Mr. Clark's argument that he believes the judge should have relied more upon Mr. Regensdorf's testimony as opposed to Judge Berkowitz's testimony. But the judge, very simply, she found one testimony to be more credible than the other. And she found that Mr. Regensdorf's testimony, where he was inclined to write off 87% of Mr. Joyce's time, obviously she found that to be unreasonable under the circumstances. And she rejected it. And she was free to do that. She was acting as the fact finder in that situation. She had every right to reject anything that she found not to be as credible as something else that she relied upon. So there's no even proof in this instance from USAA that the judge didn't have competent substantial evidence in front of her upon which to base the decision, and she outlines it in the order. So unless the court has further questions for me, and I guess Judge Stargell, did I answer your question? Because I have this nagging feeling in the back of my head that maybe I didn't fully answer your question, and I want to make sure I do that before I sit down.
Well, can you address the bad faith claims, the attorney's fees involved with that as it relates to this paragraph 7 and your paragraphs 3 and 4? Kind of elaborate a little bit more on how you feel this language took care of everything, because I view these as very, that the proposal for settlement should be completely unambiguous so that everybody knows there's no gotcha moments here. No one's trying to go, okay, you sent that, but we have this exception in here. We still have our bad faith claims. We still have these attorney's fees, so that it's all included.
So, Your Honor, and I think looking at this in the entire constellation of this area of the law is where I think I would suggest, Your Honor, take a look to grasp all this. So in order to pursue a bad faith claim under the statute, there are a couple of things that need to happen. First and foremost is the insurance company needs to receive a civil remedies notice that has been filed with the Department of Financial Services. If that's not filed with the department and served upon the insurance company, there is and never will be a bad faith claim. The second thing that needs to happen—
that was being done at the same time, right?
Yes. So the claim itself was clearly not right at the time it was asserted in this pleading. And the reason why it was asserted in the pleading was because of the Fridman case, where there had been some controversy in the law about whether you could file the bad faith case with the claim for uninsured motorist benefits, or whether that had to be filed separately. And then the sub issue that ran through that was whether the damages that were proven in the uninsured motorist case were the same damages that you could rely upon in the bad faith case, or you had to replead and reprove your damages in the bad faith case. There was some stress in the law on that was resolved by the Fridman case, which I think was maybe 2016, 2017.
Hang on, you're breaking up, or is it me?
So the consensus was put the claim into your pleading, let it get abated, which is what happened here. But that way you don't have to replead and reprove all of your damages later on in the bad faith case. Here, the complaints, every one of them says that the claim will ripen only upon certain other things happening. And those other things are prerequisites to going forward with a bad faith case. The first thing is you need to establish that you're entitled to benefits under the policy. In this case, that's not an issue because USAA never said you weren't entitled to benefits under the policy. The other thing that's required of you is that you establish what your damages are. And that would never happen. If the proposal for settlement is accepted, Mr. Bosher could never establish what his full range of damages were, could never establish the second prong of those cases, the Vest case and the Blanchard case would be the two from the Supreme Court I would commend to your honor that talk about the need to have those determinations before you can ever pursue a bad faith case. So what this offer of a proposal for settlement did was take away Mr. Bosher's ability to ever set the table for the presentation of a bad faith claim later on. His case would have been resolved by the payment of the $30,000. He never would have established the level of his damages, and he never would have been able to pursue a bad faith case.
Had I suppose the answer to the Fridman issue in this case was to file the bad faith claims with the UN claims, have them abated, would be the functional equivalent of not filing the bad faith claims at all until resolution of the UN claims.
Correct.
And if that had happened, would we be arguing over this as between paragraphs 3 and 4?
In my viewpoint, we would not.
So in your view, that's kind of a given because the bad faith claims really weren't on the table yet for purposes of the proposal for settlement law.
Correct. I mean, he was willing to give up those claims and get rid of everything, all damages. But
it doesn't say that. It doesn't say that expressly, but
well, it says resolves all damages that would otherwise be awarded in a final judgment in the action in which this proposal is served. So I don't know how you can get more than all. It's all. He's willing to give up all of the damages he could otherwise recover from USAA, period.
Well, yeah, we'll have to talk about it and look at it. I just think, in looking at paragraph 7, something to consider is, how would somebody on that other side, if you could say all means all in the attorney's fees portion as well, that this resolves everything, including any claims, rather than starting it with the wording that I can't bring up on my screen right now. But anyway, yes, you've answered the questions I have. I just have to kind of
wonder what it means.
Yeah. Well, thank you. If the court has no further questions for me, we would ask that the court affirm both judgments in this matter and to affirm Judge Peacock's decisions on both the courts. Thank you very much.
Thank you, Mr. Vaca. Mr. Clark, you got 2 minutes.
Okay, Judge Northcutt, the problem with subsection F of the rule, it states, or it says, state whether the proposal includes attorney's fees and whether attorney's fees are part of the legal claim.
Right.
What this proposal says is the proposal does not include attorney's fees and attorney's fees are not part of the legal claim. That second statement are not part of the legal claim. That is a misstatement. You cannot look at that first amended complaint and say that there was no legal claim for attorney's fees. Whether it's a valid claim or not is immaterial. It has to be addressed. That's what Horowitz says. That's what Cahuta says. Technical deficiency, invalid proposal.
Well, so that's the question. The language in 7 is not ambiguous. It creates a technical deficiency. Is that what you're saying?
It is both. It is both. It
says what it says. And you're saying it's ambiguous because of what is set forth in the complaint.
Correct. And that's why I think this court's the recent opinion with that Judge Atkinson ordered is so important and addresses sort of what it does address what Mr. Vaca said. You can't ignore this language, and you cannot ignore that this is not just a contractual claim for UN benefits as pled. It was abated, wasn't dismissed, it was on the table, okay? It was there. And there are damages separate and distinct, including attorney's fees and claims for attorney's fees that were at issue when this proposal was served. It is not mooted by acceptance of that. And what Mr. Vaca suggested was, well, if Mr. Joyce came and tried to argue this, he'd likely be sanctioned. Well, we don't know what he was going to argue. And that's the point. We shouldn't have to worry about that. We should be able to definitively accept and end the case. And the Senate's case addresses the point about, hey, if they just accepted it, there would have been no further case. And the majority of the court rejected that argument, saying that there were other claims out there.
All right, that's your time. You guys did a great job arguing this case, which we really appreciate. To leave our virtual courtroom, you need to click the button, the leave button in the lower right-hand corner of the Zoom screen. And after you do that, I am going to leave while we take a little break and rearrange the panel because I'm going to go on with my